Welcome everyone to the Brickcourt Chambers seminar on new UK sanctions regimes. This is our lockdown lunchtime discussion. We are very much hoping that we will be joined by Lord Anderson of Ipswich, David Anderson, but there are a couple of very minor technical hitches. So we will launch in any case. We're here to talk very excitingly about the new UK sanctions regimes, which came into force just 3 weeks ago on the 1st of January of this year. So we thought it would be a very good time to look at what they consist of and their implications. And so with us for the discussion are a number of members of Chambers who do a wide range of sanctions and other kind of work. Richard Blakeley, David Heaton, Malcolm Birdling, myself, Maya Lester, Jonathan Dawid, Fergus Randolph. We are very fortunate also to be joined by Qudsi Rasheed, a diplomat at the Foreign, Commonwealth and Development Office, who started life at Brickcourt Chambers, went on to become the UK's sanctions negotiator in Brussels at the EU and head of the sanctions unit at the Foreign, Commonwealth and now Development Office. And he was really there throughout the development of these new UK sanctions regimes. So we're really grateful that he's taking part in this conversation. There is a handout available on the website. We're not going to go through it today in this discussion because we wanted to keep it brief and discursive, but the point of the handout is for you to take away, have a look at. It's got lots of, I hope, useful links and information on it, so please do go through it either now or afterwards. The format we will be following is a sort of question and answer, slightly chaotic, I imagine, conversation among us. We've got quite a lot to cover. Please do ask us questions. We've had a couple already, which is wonderful. There should be a questions box on your webinar platform. If there's any problem with that, please just email them to marketing@brickcourt.co.uk. So I am going to start very briefly, just kicking off the discussion with a few thoughts about why the UK has new sanctions regime. The short answer is Brexit. The United Kingdom, like all other EU member states, has always done sanctioning as an EU member state and indeed as a permanent member of the UN Security Council and not on its own. So Brexit caused a very, very major change in terms of sanctions. However, the UK was very heavily involved in sanctions even before it had its own regimes. It was involved, of course, in implementing EU and UN Security Council resolutions. It was, I think it's not controversial to say, by far the most active EU member state when it came to sanctions policy and participation in the EU. I don't know what Qudsi's figures are, but I've heard that the UK was responsible for 70 or 80% or more of targeted sanctions listings in the sense of proposing those for designation in the EU. And it was extremely active in a lot of the most recent sanctions regimes, like the chemical weapons regime, cyber sanctions, human rights sanctions, and so on. But we now have our own regimes. We have a statutory scheme. We have the Sanctions Act, which was the first piece of legislation to do with Brexit that found its way through the UK Parliament. We now have new regulations for every single sanctions regime, accompanied by guidance and policy documents. So that was a lot of work done, of course, by the government, deciding which bits of EU sanctions it wished to carry over into UK law and what it wanted to do differently. And that's really what we wanted to explore with you today. And finally, I just wanted to note what a time to be discussing a whole new sanctions regime, because even by the standards of the very fast-moving world of economic sanctions, at the moment it's a time of real interest and change. First, of course, we have a new US administration who have started things off not only with a whole load of executive orders, but a new announced review of the whole of sanctions policy. So will the US continue to use sanctions, as President Trump did, as an instrument of economic warfare? Will the US try to rejoin and breathe life into the Iran nuclear deal, or indeed try to renegotiate it? China on Wednesday sanctioned the outgoing US administration. China imposed sanctions on John Bolton, Mike Pompeo, Steve Bannon, We have Alexei Navalny, of course, from prison, drawing up lists of the oligarchs he thinks should be sanctioned and challenging the European Parliament to start imposing sanctions on President Putin's inner circle, instead of, as he put it, those technically responsible for his poisoning. And we have the European Commission setting out its very active vision for EU sanctions to try to square up to US extraterritorial sanctions. So first, at a very interesting time to be drawing up an entirely new legal regime, I want to bring in, if I may, Qudsi Rasheed, who was, as I say, very involved in designing the new regime, really to tell us a bit about it. Qudsi, could you really just start by telling us what it was like preparing for UK sanctions at the FCDO between, I suppose, the time of the Brexit referendum and now?
Thanks, Maya, and thanks to you and to Brookcourt for organising this session, which looks really interesting. The short answer was it was really complex. As with lots of other areas of Brexit, as you might imagine, things did quite significantly change overnight. Perhaps not legally change overnight, but the implications of what the referendum would mean was very clear from the very outset. And as you set out, sanctions was something that we had hitherto always done through the EU or the UN. And so it really was an exercise of designing an entire policy, legal framework, architecture from scratch. There were really three elements of it, I think, that probably are worth drawing out. The first was a very kind of UK-facing one, which I think is probably largely the subject of your seminar today, or your session today, which was we had no legal framework, we had no architecture, we had no system or mechanism by which to impose sanctions. And so very quickly we had to work out what the legislative framework would be. And we designed the structure with a primary piece of legislation, a bunch of secondary legislation sitting under that, and a number of administrative decisions sitting under that, a kind of three-layer system. And that was all designed from scratch, really. And I think as much as it was challenging and it was complex, it was pretty exciting too, because it's rare in the area of public administration and public governance where you really do genuinely get to sit down with blank pieces of paper and say, what do we want to do here? And that's exactly what it was like from day one. Policy officials, lawyers, from the Foreign Office, from Treasury and other bits of government, sitting down and brainstorming ideas. What were the bits of the EU system that worked well? What were the bits that didn't work well? What could we learn from and do in our own way? And also what was idiosyncratic about our own system, our own courts, our own parliament? Obviously the EU didn't have those same systems. So designing something from scratch was really quite challenging, but exciting. The second element of it was really about our relations with others. It obviously had a very big impact on our relations within the EU immediately. I remember I was in Brussels at the time of the referendum, having to go into negotiations on the Friday morning, having not slept through the night of the referendum. And it was obviously different. Yes, it wasn't legally different, but the positions that we were taking and the nature of the negotiations obviously had a new colour to them. And so we had to think very carefully about what our future relationship with the EU was going to be and what we wanted from it. I think it was very clear, frankly, for both sides from the outset that some sort of institutional relationship in the area of foreign policy and sanctions was just not really practicable. But as with any other ally, having good diplomatic relations and working closely with the EU was something that was a clear objective from the outset. But also what was really important for the government was trying to develop and deepen our relationships with other international partners that we might work with, the Canadians, the Americans, and other like-minded countries, and thinking about how we might better develop our cooperation now that we would have our own tool in place. And the final point was really about, which is probably slightly more boring for this audience, but actually quite a lot of administrative restructuring. We in the Foreign Office and across the Treasury just didn't have quite the resources at that point in time to run a whole new independent sanctions policy. And so a lot of work went into the kind of nuts and bolts of the architecture of the right resources, the right skills, the right numbers of people with the right expertise in order to be able to deliver this. So I think what I would say overall is that we were trying to design something that substantially had the same policy objectives and the same policy effect as the EU. That makes sense because we were one of the main architects behind the EU sanctions regime, and it was delivering a UK foreign policy and foreign policy objective, but also taking into account the different context and learning the lessons of how we could improve our own system as well.
I mean, that's fascinating, Qudsi. Thank you. I mean, when you say that you didn't have enormous resources. I think it's right that the UK has vastly more sanctions resource in government than any other member state. So, I mean, are you concerned? I wonder if the EU is concerned. Are there other member states who might start to play a more active role? And if so, are there the resources to do that, do you think?
I mean, really, that's a question for the Europeans, not for me, probably. I think the EU, the European member states have always understood the importance of sanctions. That's something that I've seen firsthand throughout my career. Yes, I think it is fair to say that during our membership of the European Union, we were relied on quite a lot by other member states and the EU institutions as the key actor when it came to sanctions policy. That obviously is now going to be different, and I think it will really be for the EU member states, for the EU institutions to decide how best they can continue to deliver a policy and a tool that they think is important, and to put the resources behind it. And that's really a question, I think, for them. On our own part, we have really upped our resource in order to deliver a UK sanctions policy. And as with all of our allies, including the EU, we'll stand ready to work as closely with them as appropriate, given the particular objectives that we might share.
Okay, thank you, Qudsi, and I very much hope that we'll hear more from you as we go along. But could I just launch in with really, you've said very interestingly, Qudsi, that the intention was, broadly speaking, to follow the policy of the EU. And I know when the sanctions bill was making its way through Parliament, there was an emphasis by the government on them needing new powers more than wanting to enact a whole new kind of sanctions policy. But can I just bring David Heaton in there? Because, as I said, the government's stated intention was broadly to copy EU sanctions into UK law. But as Qudsi has said, there was a blank sheet of paper, and the UK could decide really whether to make any big changes or not. Can you just let us know what are, in fact, the key differences between UK and EU sanctions so far?
Maya, thanks. I think standing back and looking overall at new regimes, as has been pointed out, there's different drafting. The UK regimes tend to be now more precise, more detailed, the kind of English statute or SI that we as English lawyers are more used to applying. Generally speaking, it's fair to say the prohibitions do more or less mirror those that the EU implemented. But the devil really is in the detail. And as Richard has commented in his handout, it's important to always check carefully the relevant provisions. I've identified in the handout 5 groups of what I think are interesting and potentially important changes in practice. And I will spin through those now very quickly. There's further detail on each and examples of the provisions in the handout. First of all, there are changes to the asset freezing provisions and making available provisions in terms of what is actually prohibited. Whereas the EU objectively prohibited certain kinds of transactions if funds were frozen. So it was prohibited without more to move around frozen funds. The UK prohibitions are now cast in terms of prohibiting transactions with frozen assets where somebody knows or has reasonable cause to suspect that those assets are frozen. So that might have consequences in particular for arguments that certain transactions are illegal. Under the EU regime, you could have shown that something was a breach, objectively speaking, and therefore consequences could follow. Under the UK regimes, to establish the basic illegality, you're going also to have to show both some form of knowledge or suspicion. Another potentially very significant change is the definition of ownership and control in the UK regimes. So asset freezes, which aim to prevent a designated person from disposing of or using their assets, generally prohibit dealings in assets that are owned or controlled by a designated person. The UK has adopted that approach, but it has adopted a very different and arguably more expansive definition of when assets will be owned or controlled by the designated person. Richard will cover that in more detail. The second key difference is that there are differences in the country's designation and prohibitions themselves. It's not possible to cover those in the 3 minutes that I have, but very broadly speaking, you see some instances where the UK adopted regimes that at the time at least the EU didn't have, for example, the human rights regime, but the EU now has one. You also see differences in the actual designations and listings. So it's very important to check whether in practice, a listing has been carried across to UK regimes. And you also see differences in the scope of prohibitions. An example of that is the Russian prohibitions that previously had exemptions for EU subsidiaries. The UK has implemented that in a way where there are exemptions only for UK subsidiaries. That's potentially quite important in practice, particularly if people had established themselves in a way that assumed that any kind of activity in the EU by an EU entity would be all right. Thirdly, the UK nexus is now very clear, and you have in the handout section 21(1) of the Act. UK prohibitions can extend to conduct in the UK or territorial sea by anyone, and conduct elsewhere outside the UK, but only by a UK person, effectively a UK national and nationals of certain dependent territories. So for UK sanctions to apply, something has to be happening in the UK or done by a UK person. Fourth point, there are now in the UK regimes no claims clauses. Those were clauses that had the effect of preventing claims where was the sanctions that had given rise to that claim. An example of the application of those provisions is the ModSAF case that is set out in the handout. The UK regimes don't have those provisions. So there is now an open question as to whether you can claim against somebody because they have followed the sanctions and, for example, not paid a debt that is due to a designated person. And finally, you have other bespoke provisions, which in general tend to create more room for movement for the UK. I've called out a couple of examples that I find particularly or maybe of significance in the handout. Those are, first of all, a national security or crime prevention override. That's provision, an example of which is in the Iran sanctions, that effectively allows the UK government to decide that something is in the interest of national security or of preventing or detecting serious crime, and thereby permit it, notwithstanding the transaction would otherwise be prohibited. And also, there is a licensing ground, so a way to get a license to do something that would otherwise be a breach, or what is referred to as an extraordinary situation, and that applies only in the case of autonomous, i.e. non-UN mandated sanctions regimes. So those are 5 of the key differences, as I see it, between what we had and what we now have in the UK regimes.
Very helpful, thank you, David. So am I right in summarising that there are not massive changes between the EU and the UK sanctions, but the devil really is in the detail, and there are some relatively significant differences between prohibitions, listings, and so on. Can I just ask you a follow-up question, really, which is, given what you've said about UK nexus, a lot of the concern about a whole new regime is, well, now that we have a UK sanctions regime, do people now only really need to be aware of UK sanctions if they're in the UK, or will EU and indeed other sanctions still have some effect? So we can ask, for example, which lists do UK companies now actually have to screen against? And some banks, as I understand it, are saying they still don't want to engage in transactions for people on EU lists, even if they're not on UK lists. So I can imagine there will be a lot of complex questions about the territorial scope of all of this. Do you want to just clarify any of that, please?
Sure. So I think, as to your first question, it is fair to say, yes, that the prohibitions are broadly similar, but the devil is very much in the detail, and it's obviously vital to check any regime you're advising on or seeking to comply with very carefully. And the UK Finance has published very helpful, very detailed tables of the differences between those regimes. There's a link to those in the handout. As to your second question, nexus, I think the nexus itself is relatively clear. So UK sanctions apply to things done in the UK by anyone, or things done anywhere else by a UK national, or at least that is the maximum possible scope of the prohibitions, and I haven't seen any SI that is more limited in its effect. But in practice, particularly banks and financial institutions are very likely to have operations in the EU subsidiaries that might be involved in certain transactions, or to employ EU nationals who will all be required themselves to comply with the EU regime. Now, if that's the case, in practice, to go particularly where it comes to processing a financial transaction, people are very likely going to have to comply with the EU regime. And so it won't necessarily be possible to carry out transactions with EU designated persons, even where they're not on UK lists, in practice, even though there's no obligation, as a matter of strict lawfulness, on a UK person not to deal with a non-UK designated person.
Thank you very much, David. Richard Blakeley, what do you think of all of this new law? If you had to just give a few pointers for commercial parties in particular that they really now need to be aware of as compared with before, what would you point to?
Thanks, Maya. I think there are really three things to think about. The first is the expansion of the asset freeze to assets owned or controlled by designated persons, which David mentioned right at the outset of his answer. The second, I think, is the change in the licensing provisions, in particular those that impact upon pre-existing contracts and arguments that might be made around frustration or failures to perform. And the third, I think, is thinking about the drafting of sanctions clauses in existing and new contracts. So I'll just say a little bit more about each of those three topics. As Dave Heaton mentioned, the new UK regimes lay down an extended and detailed definition of the circumstances in which direct or indirect ownership or control of assets will be held to exist. And so those assets will be caught by the asset freeze provisions. Now, this is particularly interesting and expansive when you look at how it applies to corporate vehicles and to the ownership of companies. So going forward, a person will own or control a company and corporate assets where one of two conditions is satisfied. The first is where they have a direct or indirect holding of a majority of the shares or a majority of the voting shares, or otherwise have power to appoint or remove the board of directors. And the second condition is if it's reasonable to expect that in most cases or in significant respects, the company's affairs are conducted in accordance with the wishes of the designated person. Now, that second condition is potentially extremely broad indeed. It applies a reasonableness standard to the determination of ownership or control. So that's an area where the courts may well have a significant interpretive role to play, because there are elements of that second condition that may require more explanation. How do we assess reasonableness? What is meant by conducting a company's affairs in a significant respect? And how do you go about determining whether that control is exercised in most cases? So if you've done any of the oligarch type cases, you'll have seen these sprawling, multi-layered, multi-jurisdictional corporate structures. Of course, all the companies there have their own directors and they'll variously own shares in each other. But it can be said ultimately that the structure is beholden to the person sitting at the top of the corporate tree. So I think that the takeaway from that really is not only know your client, but also know your client's client. Who are they transacting with? Does a company fall within a particular corporate structure that might be associated with a sanctioned person? If so, you need to tread particularly carefully and really do your due diligence, because it may well be that the indirect control provisions are satisfied. The second point I mentioned was licensing and a change in licensing practices. The power to grant licenses is now found in Section 15 of the Sanctions Act. And there is a power to grant general or specific licenses, and the availability of a general license for a general category of transactions or group of persons is a change from the prior regime and seems to borrow from OFAC's practice of issuing a general license. A key feature of the licensing regime going forward is going to be the fact that licenses can only be granted for particular enumerated statutory purposes. So while we can all breathe a bit of a sigh of relief that legal expenses are on that list, the list is otherwise quite narrow. A key one will be a license to satisfy prior obligations, although it's not clear to me, having looked at a handful of the statutory instruments, whether that is incorporated in each of them. So you need to check the statutory instrument carefully in each case. but there's also a power to grant a license to enable anything to be done to deal with an extraordinary situation. So it's going to be interesting to see how broadly that's interpreted, whether by the Treasury or the courts, as to what will be sufficiently extraordinary for the purposes of a license. And that's going to be relevant not just for getting transactions through, but also for arguments about whether an agreement is frustrated or whether non-performance is excused by the subsequent imposition of sanctions. We don't really have time to get into the ins and outs of the law of frustration today, but a key point that has emerged from the authorities, albeit in a somewhat muddled way, is that if a license is available, then there usually won't be frustration, and it appears that it's incumbent upon a party raising frustration to have already sought and failed to get a license before it can come to the court and make that argument. The third point that I mentioned at the outset that I want to touch on briefly is sanctions clauses. And all I'll really say there is to make sure that your clauses are drafted broadly enough to catch UK sanctions. And the safest way to do that is to make express reference to the economic sanctions and restrictive measures imposed by the UK in the clause itself. But you also need to think carefully about what level of risk you're trying to exclude. Are you concerned to exclude any risk that sanctions might apply to a particular payment or transaction? Or are you concerned at some higher standard, i.e. whether sanctions would definitely be breached by making a particular payment? So in the Mamon-Koche mining case, which is a case that I did a couple of years ago, the sanctions clause in that case applied wherever a payment by insurers would expose them to the restrictive measures of various different countries. Now that was quite narrowly construed by the courts, and it was required to be shown that there would be a breach of sanctions by making any particular payment, and not some lesser standard of risk of exposure or risk of breach. And that's quite important where we're operating in a territory that is in part discretionary, the granting of licenses, or at the very least entails an evaluative exercise by a regulatory body, such as determining whether it's reasonable to consider that there is control of a corporate entity. So coming back round to where I started, the second limb of that ownership or control test referred to it being reasonable to consider that a company was controlled by a designated person. And that sort of uncertainty feeds down into the question of whether a sanctions clause might apply or not. So again, particular care is required when drafting those clauses.
Thanks very much, Richard. And you're right. I mean, there's been a series of cases, hasn't there, where the courts have grappled with these issues about, well, what is the effect of sanctions on contractual obligations? And what about the effect of sanctions that don't strictly apply? I'm thinking of the La Mesa case we were involved in, but are still highly relevant to the UK. Notably these powerful US secondary sanctions. So I think the courts will now have to grapple even more with these issues of sanctions clauses, what happens about contracts where there isn't a sanctions clause, and so on. I mean, for me, one of the key points you raise is licensing powers, because for those who don't know, licensing is really just granting exceptions to asset freezing provisions. And I was talking to Qudsi earlier about the importance of resourcing. One thing that strikes me is that OFSI, the part of the Treasury whose job it is to look at all of these licensing requests, is fairly deluged, I think, with requests. And there may be real difficulties with being able to respond in a timely manner to requests, not only for legal services licenses, but for all sorts of licenses, so that commercial parties can actually operate efficiently. And that's a really key part of the system. I think it is fair to say, though, that the licensing, although you're right, of course, that the licenses can only be granted for certain enumerated reasons, they are much broader and more flexible than the reasons that EU law permitted license to be granted. So my own view is that there'll be a bit less having to kind of shoehorn yourself into a slightly artificial category. And hopefully, anyway, the authorities might now have the discretion to take a broader view of what they can grant that obviously won't cut against the fundamental purpose of the sanctions regime.
Yeah, I think I agree with that, Maya. And I think we've seen previously that the Treasury has been more flexible and certainly more willing to engage than its sort of some of its EU counterparts. and the way the new regime is structured suggests that's where they'll be going. I mean, one of the exceptions is for humanitarian reasons. I've seen we've had a question about that, and I think that's something that Qudsi is well placed to talk about.
I think, and he's going to do that. Can I just though move on to a slightly different topic, just so that we get through key points and then focus in a bit more, because I want to talk a bit about, or ask a bit about, the whole issue of targeted sanctions. So these are the bits of UK and indeed all sanctions that are not broad prohibitions on everyone, but just prohibitions on particular lists of people and entities. Now, the UK now has a brand new system, obviously for listing, but also for people to be able to request variations or delistings. So the system before is that if you wanted to request a delisting and you were on an EU sanctions list, you had to go to the General Court in Luxembourg and the authorities in Brussels because it was a matter of EU law. Now, of course, it's a matter of UK law. You can ask the UK authorities. So Malcolm, Birdling, can you just briefly describe, please, how this new system of review and judicial review of listings will work, please?
Sure. In the handout, you'll see that I've set out the various statutory provisions, so don't worry about taking a note, if any of you are taking a note of that, because you'll find the references all there. But SAMLA sets out in section 22 to 33 a process for revocation, variation and review by the minister and then subsequently potentially by the court in 38 to 40 of the Act. And there's also some temporary powers that apply just for the first 2 years, which allow changes to be made to the EU sanctions regime, which has been retained to domestic law, which allow ministers to add or remove names from the designated list that we sort of carried over from the EU level. And then there's some secondary regulations which came into force in January 2019, which set out the procedure, but there's not a great deal of detail there. So the starting point is, if you want to get off the list, you, the designated person, can ask the minister to revoke or vary the designation. And it's fair to say that the statutory intention was not that this was going to be a particularly searching review. If you read the explanatory notes, it's described as an administrative review. So if a person thinks they've been misidentified, or that the designation doesn't reach the required evidentiary threshold, they can ask the minister to have a look. Then, if you are unlucky enough to be a UN designated individual, the process is in section 25. This is a departure from the EU regime because all you can do is ask the appropriate minister to use their best endeavours to prevail upon the UN to remove you from the relevant UN instrument. The court is no better place. They can't order you to be delisted, and that's a departure from the EU regime. So you'll be in a worse position now than when we were in Europe. Section 36 gives individuals included on a retained EU sanctions list the right to request a direction that they be removed. And then once you've made your request to the minister's got to decide whether to comply with the request. There's actually a statutory requirement for them to consider it. It's not sort of left at large. And furthermore, they've got to do that as soon as reasonably practicable. And there's also a duty on the minister to provide reasons. So that's all quite helpful. The minister's powers on this review are both to revoke and vary. So again, they can do sort of whatever they consider appropriate. There is helpfully a mandatory duty to revoke a designation where the required conditions of the power aren't met. So that's quite strong, actually. And the minister must therefore revoke the designation of a named person when they don't have reasonable grounds to suspect the person is an involved person as defined by the Act, or no longer considers it's appropriate to maintain the designation for the purposes set out in Section 1.3 of the Act, or considers it's no longer appropriate to maintain that designation, having regard to the likely significant effects of the designation on that person. So once a person has made the request and the request has been refused, assuming it's been refused, they can't make a further request unless they can show there's a significant matter of which the government was not aware. So you can't keep going back unless there's some significant new evidence. Other point to make is that while you can apply to get yourself removed from the UK or to prevail upon the UN to remove you from the UN list, there isn't anything you can do domestically about your EU level listing. That's something you're going to have to take up at the EU level because obviously we've left. Section 24 imposes a positive duty on the government to conduct a periodic review of sanctions and qualifying decisions as defined in the Act. And they've got to do that every 3 years, and then they've got to do a further review every 3 years. Don't know how searching that is going to be. It's less frequent than under the EU regime where it's annual, but I think it's fair to say that the intensity of review conducted during those periodic reviews at EU level is debatable. Then Section 38 provides your right to go to court. So you've got to go through the administrative process that I've just described first, and then you can bring your challenge to court. There's a list in Section 38 about what you can actually challenge in court, and duty to designations to implement UN sanctions aren't on that list. So again, you're in a worse position than you were under the EU regime. The courts are obliged to apply the principles applicable on an application for judicial review, and it's sort of interesting what that might mean. We'll come back to that a bit later, I think. And then the court, another point to bear in mind is that the court is not empowered to award damages unless it's satisfied that the tort of negligence was committed or the decision was taken in bad faith. So that's a restriction on what might be thought to be otherwise available claims for compensation. So that, in a trot, is the new regime.
Thanks very much indeed, Malcolm. I mean, I think there will be, as the first cases in the UK start to come through, I think it will be very interesting to compare, of course, the approach of the UK courts and to the court in Luxembourg to delisting challenges that there will undoubtedly be. I mean, it strikes me, first of all, one of the key battlegrounds, if you like, in the court in Luxembourg on delistings is about what kind of evidence is needed for someone to be on a sanctions list. And the sort of evidence you typically see for EU sanctions tend to be press reports and internet reports. And the court has accepted those as being evidence, and interestingly not really placed any weight on the evidence of the companies unless they come in the form of some sort of third-party evidence. So witness statements and affidavits, even sworn, are not regarded as being robust evidence in Luxembourg, but press reports are. Now, my view, you can probably tell from the loaded way I'm putting this point, is that the UK court is likely to take a different view of that. But another interesting point you mentioned, Malcolm, I think, is that there is provision in the UK for closed material procedures. In other words, if there are cases where the government relies on national security sensitive material, then there's a procedure for that to take place, as it were, behind closed doors. Although in theory there is such a procedure in Luxembourg, that doesn't often happen. So to the extent that there is intelligence material, we again may see some really interesting differences there. It also seems to me, undoubtedly, I hope, the courts will be swifter in the way that they deal with the cases than the European Court, which has a very big backlog and tends to be quite slow. I'd really like to bring Qudsi in at this point, but just one more question, Malcolm, if you don't mind. Could you just say a word about the human rights regime? Because interestingly, yeah, the one of the first, I suppose, proactive steps that the UK took, even before we left EU law at the end of last year, was to enact a new UK global human rights regime, a bit like the one that the US and Canada have had for a long time and used very actively. The EU then followed after that. Can you just say, in a nutshell, really, what that new human rights regime is and how it differs a bit from what the EU has now done?
Sure. So the new human rights sanction regime set out in the Global Human Rights Sanctions Regulations 2020. Again, the reference is in the handout. And it can be used to impose sanctions for, there's a qualification, there must be serious violations and abuses of 3 human rights. And those rights, the right to life, the right not to be subjected to torture or cruel or inhuman or degrading treatment or punishment, and the right to be free from slavery, not to be held in servitude or required to perform forced or compulsory labour. So it's limited to that level of conduct. A person can be designated by the Secretary of State if they have reasonable grounds to suspect that the person is an involved person, and an involved person is defined quite broadly, because that's someone who has been involved with one of those abuses of those rights, or is owned or controlled directly or indirectly by someone who's controlled, is acting on behalf of or at the direction of that person, or is a member of or associated with a person who's been so involved. So it's actually quite a broad category of people who are potentially caught, and that I think is no mistake. I mean, that's designed to capture a broad level of conduct, because otherwise it can be difficult to pin people down. The regulations also prevent anyone from dealing with funds or economic resources owned, held, or controlled by a designated person if they know or have reasonable cause to suspect they're dealing with such funds. And then this is subject to exceptions that are in Part 5 of the regulations. There's also a requirement for the minister to determine that it's appropriate to designate such a person, which I suspect when one comes to inevitable litigation about the scope of these powers will be an interesting point to watch. Just a word or two on the EU regime. The UK were the trailblazers. They got in first, as you said, Maya. The EU regime is actually broader, because the list, as I mentioned, of rights that potentially get you on the hook in the UK is quite narrowly crafted, although there is a power to add to those. But at the EU level, it covers genocide, crimes against humanity, violations of sort of a number of human rights, torture, slavery, extrajudicial summary or arbitrary executions or killings and forced disappearance, arbitrary arrest, detentions, and other human rights violations that are widespread, systematic, or otherwise of serious concerns as regards the objective of foreign and security policy set out in Article 21 of the treaty, which is people trafficking, gender and sexual-based violence, violations or abuses of freedom of assembly and association, opinion and expression, religion or belief. So that is very broad indeed, and the UK regime doesn't go that far.
Thank you very much. Can I just briefly ask Qudsi? I mean, the Foreign, Commonwealth and Development Office, as I understand it, went through the evidence to some extent for all 1,000-odd people and companies on EU sanctions list to decide to carry them over, whether to carry them over into UK law. And I just really wondered, I mean, first of all, that's an immense task. Is that really what the government did and had to do? What was that like? What approach did you take? And in particular, why was that engaged in, given that the UK had presumably been voting on sanctions designations as a member of the EU anyway? So would the UK not have been concerned about whether there were reasonable grounds to suspect that these people had engaged in the conduct they were accused of? Indeed, it was appropriate to sanction them already. So why was this a new exercise?
So maybe I'll start with your second question first, and then say what the exercise was, the logical sense. yes, we were involved in all of the decisions that were taken to list all of these individuals. Unanimity, the UK voted in favour of them at the EU, but obviously applying EU law and the EU framework and the EU legislation and the understanding of how we thought the EU courts would interpret those decisions, which, as you described yourself, would be quite different from perhaps how a UK administrative law approach might be, or how the UK courts might see it. So that exercise had to be done, because at the point that all of those individuals were designated under the UK regulations, they were UK decisions by UK ministers and by the UK government that were then judicially reviewable in UK court in a way that they wouldn't have been done previously. So it was necessary for officials and ministers to satisfy themselves that it was appropriate and proportionate, and that all the other legal tests in the Sanctions Act and the secondary legislation were met when designating all of those individuals. So as a result, yes, officials, a large number of them who worked very hard and very diligently over the last year or two, did go through every single designation in the EU that we were looking to bring across from the EU to determine whether or not there was enough of a basis upon which the government could make decisions to designate those individuals under the relevant tests under the UK legislation. And so, yes, it was a vast exercise. And also, a lot of the preparatory work could be done early, but as you might understand, a lot of the actual technical legal work to analyse all of those designations could only be done really once the actual legislation had been finalised, so that we can make a decision to work out whether or not relevant tests within the secondary legislation have been met.
And that's fascinating. I mean, just thinking back to when you were in working on cases, including for the targets of sanctions, did you find that your perspective really shifted working for the government on the process of listing? I guess you were really the ultimate poacher turned gamekeeper, and what was that like?
Yeah, it was different. It's different, as you might imagine. I was almost 15 years younger for a start when I was doing this, so I think perspectives on life change as well. But I think the thing is, as a private practice lawyer, barrister, or solicitor, you've got one objective, which is defending and advancing the interests of your client, and that's about it. And it's possible to be quite focused and single-minded on that one objective. I think in government, when you're taking these sorts of decisions, there are a whole range of factors to take into account: legal factors, political factors, policy factors, international relations, and so on and so forth. So I think that the first reflection on that really is that the number of factors that you really have to take into account differ. I think the second point I'd probably say is actually I was quite impressed by the importance that government officials did and will take on the legal robustness of designations. That was definitely the case when we were still in the EU. The UK was at the forefront of ensuring designations at the EU were lawful, that were respectful of human rights of the individuals that were designated, and if not, then should not be continued. And likewise, with our new sanctions regimes, it's the same approach, that the rights of the individuals listed have to be respected, and that's partly pragmatic. No government, no administration wants its designations to be overturned by a court, but equally it's kind of part of the objectives of the sanctions regimes, in the sense of it's not in anyone's foreign policy objectives to have designated persons in court. It's not in anyone's interest to sanction people for human rights abuses and have a court say you're not following your own human rights. So it's important that these sanctions are robust from a legal perspective.
Can I move, please, to the other important issue here of export control and indeed US sanctions and the blocking regulation post-Brexit, both issues that we've been asked quite a lot about. Could I bring in Jonathan Dawid first, just to outline briefly how export controls, as opposed to sanctions, are affected by Brexit, please?
Thanks, Maya. Well, export controls are, of course, one area you might have expected to see significant change after Brexit, because they're all about international trade, and one of the key benefits or supposed benefits of Brexit is Britain's ability to set an independent trade policy. And just a quick reminder, when we're referring to export controls, I'm talking about controls on exports of things like military goods, dual-use technology, in other words, goods for military and civilian purposes, or technology used for weapons of mass destruction. And historically, pre-Brexit, export controls have been governed by a hybrid regime. There's a mix of UK law and EU law, principal UK instruments being the Export Control Act and Export Control Order, and a variety of EU instruments, of which the one you probably come across most often is the dual use regulation. Now, following the end of a Brexit transition period, that EU legislation on export controls has been kept on as retained EU legislation, while the UK legislation had been amended, but not in very significant ways. So superficially, it looks like nothing much has changed in export controls post-Brexit. But that superficial continuity does actually hide some pretty significant changes, and there's just four I'm going to focus on in the time available to me. The first significant change is that whereas before export controls are very much focused on exports out of the EU, so going from Britain to countries outside the EU, there were some controls on exports within the EU, but much less. Now you need a license for any export of controlled items from Great Britain into the EU. And when I say Great Britain, I'm choosing my words carefully, as you'll see. So British exporters now need to think about getting licenses for exports into the EU of items they may not have needed licenses for beforehand. A second practical change is that under the EU regime, it was possible to get export licenses issued by other EU member states in appropriate circumstances, or to take advantage of EU-wide authorizations for exports. Well, those are, of course, no longer valid for exports from Britain. Now we're no longer in the EU. That said, to make things easier, the government has copied over some of the export authorizations as retained export authorizations, and registrations are going to be automatically carried over. So practically, that should make things easier. A third major difference is for exports going the other way. Great Britain is, of course, now treated as a third country from the perspective of exports coming from the EU to Britain. So any imports of items from the EU that are subject to EU export control legislation will need to be licensed by the authorities of the exporting state. Again, to make things easier, the EU has added the UK as a permitted destination under the main General Export Authority, the 001 Export Authority, which means that most dual-use items can still be exported from the EU to the UK without the need for standard license, although they'll register under that authority. Last, but far from least, is that under the Northern Ireland Protocol, EU export control legislation remains directly applicable in Northern Ireland. So while the rest of the UK makes do with retained export control legislation, Northern Ireland still has from the perspective of export controls, we treat Northern Ireland as if it was still the EU for most purposes. And that has some pretty significant consequences. Right now, well, there are different licensing requirements for exports from Northern Ireland to the EU and from the EU into Northern Ireland than there are from the rest of the UK, from Great Britain in and out of the EU. And that's going to get even worse in the future because EU export control legislation is evolving. There's a new dual-use regulation due to come into effect in 2021, which means that the dual-use regulation as it applies directly in Northern Ireland will change, but Parliament will have to decide whether or not to update the retained dual-use regulation as it applies in the rest of Britain. If Parliament doesn't copy it word for word, there's going to be different regimes applicable for Northern Ireland, even for exports outside of the EU. At present, there's no export control between Great Britain and Northern Ireland. And I can see how that works at the moment when EU and UK legislation more or less in sync, but it may be interesting to see if that can continue as the two regimes diverge, because there's an obvious potential for regulatory arbitrage between the two regimes. And perhaps most significantly is that under the Northern Ireland Protocol, the Court of Justice of the European Union continues to have competence over Northern Ireland law as it relates to export controls. And I think that's very significant because the Export Control Act, the UK legislation, is UK-wide. It's got nuts and bolts on to deal with Northern Ireland, but most of its core provisions apply to Northern Ireland and to Great Britain. So we've got a situation where in Northern Ireland, courts have to interpret the Export Control Act and Export Control Order in conformity with EU law, but courts in the rest of the UK and Great Britain can take a different approach. Will they, won't they? I don't know, but it's certainly not hard to see that that could lead to political as well as some legal tensions if you have EU law requiring Northern Ireland to do things differently from the rest of the UK.
That's fascinating. Thank you very, very much, Jonathan. Interesting work for the Northern Irish Export Control EU bar. David Anderson, shall we try to bring you back in again? No, can't hear currently.
Okay. Can you hear me now?
Yes,
can you hear me now?
We can. That's wonderful. Wonderful
right.
news.
Fire away.
So the question I asked you was about really your findings from your House of Lords committee on the impact of all of this, really on the impact of Brexit on sanctions. What have people been saying?
I think there's a consensus that by going our own way on sanctions, we are achieving nimbleness that we didn't have before, but we're sacrificing heft in that we can't automatically take lots of others with us. The government, in its evidence, as you would expect, has been very keen to show us the advantages of nimbleness and our ability to make common cause with a range of other countries, as we've seen, for example, with the Canadians over Ukrainian sanctions. What we haven't detected from ministers is any readiness, or at least any admitted readiness, to contemplate formal procedures to coordinate policy with the EU. And that, in fact, applies across foreign policy and development policy generally, not just to sanctions. But it may be that bilaterally and behind the scenes, that is different. We saw that with the poisoners of Navalny, where there was a Franco-German initiative and the UK immediately backed it up. It didn't feel like pure chance. Whether we can retain our historic role delivering EU sanctions at the behest of the US, which I used to observe particularly in the counter-terrorism field, is another matter. It may be the US will strengthen its bilateral relationships with remaining members. When it comes to challenging sanctions, the evidence we received, which I recall came mostly from you, Maya, was that judicial review was likely to be more effective in our courts than it was before the General Court of the EU. I hope you were right.
Well, we'll have to see. Time will tell. Probably depends on your definition of effectiveness as well. But actually on that topic and what you say about nimbleness is, of course, completely right. I mean, one of the results of the review that Qudsi talked about is that most, but not all, of the designations of the list of targets have been brought into UK law. And very notably, none of those on the lists relating to the former regimes in Egypt, Ukraine, and Tunisia have been brought into UK law, at least as listings for their EU listings, which were for misappropriating, stealing state funds. And now, David, you acted in the Court of Justice for the former President Mubarak and family in relation to the Egypt version of those lists. And the court annulled those sanctions. And indeed, the Ukraine and Egypt and Tunisia lists have all been treated with scepticism by the European Court. So what did you think when you saw that the UK had not brought those listings over? Do you think that was the right decision?
Well, as it happens, I had the opportunity to ask the Minister that question on Tuesday when he came to give evidence before our committee. I think there were something like 60 individuals on the misappropriation lists for the three countries you mentioned, of which very few have been carried over into the UK. And I think the ones that were carried over onto different lists, whether that's Magnitsky or whether that's Ukrainians going onto the Russia list. So it did look rather like a policy decision, though the Minister answered me, or got his civil servant to answer me, by saying that this was simply the product of a case-by-case analysis in which each case was measured against the standards of SAMLA and found wanting. There are, of course, and perhaps I'm biased because I have, as you say, just done the Mubarak case, but I think there are some particular difficulties about this misappropriation regimes. They are at least open to the possibility that a somewhat unscrupulous regime might seek to use these sanctions mechanisms in order to exact retribution on somebody who has fallen out of favour politically. And there has been a particular difficulty in the EU Council actually relying on evidence coming from those regimes. And that was what the Court of Justice said couldn't be done in the Ukrainian cases. And I was very pleased to see that in the Mubarak case in December, they effectively read that ruling over to the case of Egypt and my clients, the Mubarak family.
Absolutely, I agree with those sort of really basic rule of law concerns about those lists, relying on those jurisdictions for the EU to carry out its duties seems to me really problematic. I mean, I've never really understood the point about different legal tests, and Qudsi, perhaps if we have time at the end, you could come back on it. But the government justified the test in the Sanctions Act of reasonable grounds to suspect on the basis that it was the same as the test that it uses in the EU, and basically the same as the European Court's test of sufficient factual basis. So to me, the legal tests look the same. But anyway, David, while we're on the subject of listings, another great case you were in was the famous Qudsi case, where you persuaded the Court of Justice that if the EU implemented a UN listing unfairly, the EU listing should be quashed. Now, the Sanctions Act doesn't do that. Does that trouble you also in rule of law terms, that judges are simply not allowed to delete someone from a list, even if the evidence is that they shouldn't be on one?
Well, yes, I did do the first Qudsi case and the General Court in the second Qudsi case, but you took over, of course, and won triumphantly second time around. Those cases were very popular with human rights lawyers, but they caused some concern with international lawyers who saw the judgments as an erosion of the binding force of the UN Charter. And that's a tension we've seen in many other contexts. Very recently in Parliament, in the genocide amendment to the trade bill, which was recently very narrowly defeated in the House of Commons after a large conservative rebellion. And this would have enabled a trade agreement to be repudiated in the case of genocide being proved, for example, against China. It's very popular with human rights lawyers, people concerned about the Uyghurs, but it did generate a degree of concern from public international lawyers who don't think that customary international law or treaty law currently permits unilateral breaches of treaty obligations, even when the treaty partner is accused of something as serious as genocide. So I think this is an age-old conflict, international law against human rights. You might think it's a little ironic that in SAMLA, despite, I think, attempts by Lord Pannick to amend the bill as it went through, the government has come down firmly on the side of international law.
Thank you. Fascinating. Do you think that Parliament will play quite a role in the new UK sanctions regimes? Because most of the power is, of course, delegated to ministers, but there are quite significant reporting duties, and certainly a number of parliamentary subcommittees have taken a real interest in sanctions. Do you think that will continue?
There's a huge interest on the floor of both houses in the politics and the policy of sanctions issues, as we're seeing at the moment, for example, with Magnitsky sanctions and interest in particular in sanctioning Chinese individuals associated with Hong Kong and with treatment of the Uyghurs. I'm sure that will continue. In terms of nuts and bolts scrutiny, there has been a certain amount from the EU committee in the House of Lords and its subcommittees, one of which I sit on. And they have really been the centre of the House of Lords committee structure. They account currently for more than half its committee resource. That is all changing. That resource is being scaled back after Brexit, making way for some new Lords committees, including an International Agreements Committee and a Justice and Home Affairs Committee. So it may be that the Foreign Affairs Committee in the Commons will become the most obvious place for these sorts of nuts and bolts investigations to take place. I certainly hope they continue to do so.
And is it a matter of regret, do you think, that there was an amendment tabled but not passed to the Sanctions Act to allow the independent reviewer role to review sanctions designations as well as terrorist asset freeze Do you think that was the right decision?
Well, having been an independent reviewer, I'm keen on independent review, but it cannot ultimately be a substitute for review by Parliament and the courts. And I think there are particular factors that make independent review more appropriate in the counter-terrorism field, where it remains under SAMLA, where sanctions are concerned, and that is the classified nature of the information involved and the consequent inability of Parliament, whose members do not have privileged access to security materials, to perform their own scrutiny. There's also the fact, I suppose, that terrorist asset freezing measures are imposed, at least to some extent, on our own citizens. So it would have been nice, but the battle was lost as the bill went through, and I can't see it happening, certainly in the short term.
Thank you very much. Just before I pass to our last really important topic, which is the blocking regulation, which we've been asked questions thick and fast about, I just wanted to let Qudsi come back in, because I'm aware we've said a lot about the government for which he works, and I just wondered, Qudsi, if you had any final comments.
Thanks, Maya. Just a couple of reflections, I think, really, more than anything else. I think first of all, your point and David's point about surely the legal test is the same in the EU as it is in the UK, so why a different approach? I think the legal tests are aiming for the same policy objective and the same policy effect, but are different. How a UK statute exists, how it will be interpreted, how we expect it might be interpreted by the court will be different from how it's interpreted by the EU. And so I think David mentioned misappropriation regimes, and I think it's right. I hadn't seen the evidence session myself, but it's absolutely right that each case will be looked at individually to see, has the legal test been met? And if the UK government took the view that it hasn't been met, it would have been unlawful for the UK to carry over that listing. That doesn't say anything about the EU listing. That's now a matter for the EU to decide whether or not those listings continue to be lawful under their own legal tests. We have to decide whether it's appropriate and proportionate under our own legislation. I think that was really the main point I really wanted to come back in on, unless there was anything more specific.
That's brilliant. Just the topic, Fergus Randolph, that you're going to take us through of the blocking regulation is a fascinating one, because of course there's been some concern in the EU that some US sanctions are, having more of an impact here than even sanctions that are more technically legally applicable. So the EU has its blocking regulation, and the UK, as I understand it, now has its own UK version. So could you just take us through those and what the UK has decided to do about that?
I can indeed. Sorry, I just pressed the wrong button. As you said, Maya, and thank you for organising this webinar. There have been a lot of questions on that we've seen on the blocking regulation, known as the blocking statute in the EU, the blocking regulation in the UK. I don't think there's something important about that, but that's if you hear about the blocking statute, that's from the EU. We've had a number of questions about what is the impact of the new sanctions regime on the blocking statute / regulation. The first point to note is that the blocking, I'll call it the regulation, the blocking regulation, the 96 Council regulation, is now part of retained direct EU legislation. But it's not fit for purpose in a post-Brexit world, because, as you'll all recall, doubtless, the blocking regulation protects, and I'm going to underline this, EU operators from the extraterritorial application of what is euphemistically called third country laws, aka US laws. And those laws identified are the US laws in relation to Cuba, Iran, and Libya. And the EU doesn't recognize the extraterritorial effect and seeks to protect, underline, EU operators by nullifying the effect in the EU of any foreign court finding based on those foreign laws, and allows those, underline again, EU operators to recover damages for loss caused by any extraterritorial application of those specified laws. Well, clearly, insofar as the UK wanted to continue to be part of an approach which blocked the extraterritorial application of certain laws, there's no reason why it wouldn't, it's a matter of international law, it had to change the position. And it did so through the snappily titled the Protecting Against the Effects of the Extraterritorial Application of Third Country Legislation, bracket, amendment, another bracket, EU exit, close bracket, regulations 2020. And that essentially, in large part, amends the, as I said, the retained direct EU legislation, that is the EU blocking regulation, by changing EU operator for UK operator. So that's the first point. And this picks up, I'm just going to say something that picks up on something that's been raised in a question. Important to note, that the blocking statute, the UK blocking statute, will apply obviously to UK economic operators, that makes sense. But what is a UK economic operator? According to the explanatory memorandum / government guidance, UK branches of US businesses are not considered to be UK economic operators and therefore not subject to the retained EU blocking statute. UK subsidiaries of US businesses are, on the other hand, covered. That's the first point. The second point is that instead of the Commission having the power to amend the list of third country legislation that could be covered by the EU blocking regulation, and just add to that, and this picks up on a question, in the policy paper that was produced by the Commission 2 or 3 days ago, it's no longer going to be just the Commission. They are going to have representatives of the European External Action Service who will have a mandate to review technical implementation of EU sanctions and the blocking regulation. So that's just an aside. But instead of the Commission / the EEAS dealing with third country legislation, amending it, adding it, subtracting it from the blocking regulation, you're going to have the UK Secretary of State for International Trade doing that. Now that brings to my mind the possibility of divergence, because you may have a UK foreign policy approach which is not, say, to include certain legislation from the US as being covered by the blocking regulation. So watch this space. Obviously, it's only 3 weeks old, but that is a potential for divergence. And then 2 other small points in terms of differences. Persons affected by the relevant third country legislation must now inform the UK authorities, that'll be the Department for International Trade, rather than the Commission, within 30 days or risk a fine. And finally, authorizations to comply with extraterritorial legislation will now be a matter for the UK Secretary of State and not the Commission. And you'll recall that that's the Commission implementing regulation lays down the criteria whereby authorizations can be given in exceptional circumstances. So that is another area, I would suggest, where the UK may well diverge from the Commission and take its own path and use its own criteria, but it's too early to tell.
Thanks very much, Fergus. I mean, one of the most striking things about the blocking regulation and also its UK counterpart is really to try and work out what it actually means. I mean, even by the purposes of EU legislation, it's quite an unclear document, including even about basic things like what remedies does it give rise to and who can bring a case and against who. It's all, you know, interestingly up for grabs is one way of putting it. But there are, I think, at least 2 and possibly 3 current cases before the Court of Justice, aren't there, I think, asking for clarification of bits of the blocking regulation. And obviously the UK courts will be going to interpret our own version of it. I mean, in terms of whether it actually in practice has any teeth and does anything. My understanding is that there have been quite a few cases in different member state courts where courts have granted injunctions to stop actions taking place, like people being cut off from contractual relations, for example, if it's a breach of the blocking regulation. So a few injunctions. I'm not sure at all how active the sort of investigations at a national level for breach of the blocking regulation, or indeed the granting of authorizations, has been. And I know one of the questions we've been asked is, is the UK likely to take a more active approach to its own version? Do you have any thoughts on that?
Well, I can only speak from my experience, just picking up on your first question or reference to cases. I think the main case that one really will be looking forward to in terms of the Court of Justice giving its ruling on a preliminary reference is from the Hamburg Court in Bank Melli and Telekom Deutschland, which is exactly that, it's a contractual case. And the key question referred goes exactly to scope. Does the first paragraph of Article 5 of the blocking regulation only apply where the acting EU operator within the meaning of Article 11 is issued directly or indirectly with an official court order, or does it suffice for its application that the action of the EU operator is predicated on compliance with secondary sanctions? Now, the court, the first instance court in Germany, said, oh, well, we think it's the first. In other words, you've got to have it issued directly or indirectly. Whereas the second, the referring court, said, no, we are of the view that it suffices that the action of the operator is simply predicated on compliance, which is, I think, where most people would come down to. But because there was a difference of opinion, that's been referred. I'm involved in a case which is contractual in nature. And interestingly enough, a branch of the police investigatory authority has become involved. Now, I wasn't aware that this would be a matter for that part of the police authority, but anyway, it is, and they are investigating. So in answer to your question and the question that's been asked of us, it looks as if the UK authorities are taking this seriously. Whatever happens with that investigation, one thinks that my case will come to trial and watch this space. But I would finish, if I may, on an interesting case from the French Court of Appeal in July, decision of the Paris Court of Appeal in T against N. Not 100% sure why everything had to be anonymized, but anyway, there we are. There's no direct reliance on the blocking regulations there because the sanctions in questions weren't covered weren't within the specified US laws. But the French court used its own 1968 domestic blocking law, loi de blocage, to prohibit the extraterritorial effect of the US sanctions in that case against Iran. So that's very interesting, because I had always thought this was a construct from the EU 96 going forward. But actually, this shows that back in 1968, other than throwing cobbles, there was quite a lot going on in the French legislature in terms of producing a domestic blocking act.
Thank you very much. Well, like all of the topics that we've really only scratched the surface of, there's an awful lot that could be said. I'm conscious we've answered some, but by no means all of the questions that have been coming in. They're all very good questions. If we have your contact details, we will try to come back to you. If we don't, all of our contact details are on the handout on the website. So please do look at that and feel free to ask us again. And I think the level of interest in this and all of the topics that really come down to watch this space and let's see how UK sanctions are applied lead me to think that another event, perhaps a year on, would be good. But if there are particular aspects of this that you think would merit a more focused look, I'm conscious that we've really touched on a little bit of everything. Please let us know. The last event that Brick Court Chambers hosted on post-Brexit sanctions was in the rather glamorous Savoy Hotel in London. And I very much hope that next time we see everyone, it'll be in a setting like that and not watching computer screens. So thank you very much. There's also, I should say, much more information about all of this and more daily updates than you could ever want on the blog that I co-write, europeansanctions.com. So please do sign up for those free updates should you wish to do so. And thank you very, very much for coming and staying the course with us. Thank you.